4, Australian Charities and Not-for-Profits Commission Bill 2012, resumption of debate on the second reading.
The question is that this bill be now read a second time. I call the member for Menzies.
Thank you, Madam Acting Deputy Speaker. I rise to speak on the Australian Charities and Not-for-Profits Commission Bill. And in doing so, I'd like to outline the Coalition's approach to the not-for-profit sector, or civil society as I would prefer to name it. The description not-for-profit immediately connotes an economic framework, whereas civil society involves a different, broader notion of which the economic is just one part. The Productivity Commission itself accepted this broader role for the sector and noted the tensions that arise from the conflict between economic and other objectives. Civil society comprises the groups of individuals which freely associate to pursue their mutual social, cultural, professional, sporting, religious or other communal interests. They are neither instruments nor agents of the state. They're the local carers groups in the towns and cities of this nation. They're the sporting clubs, the congregations, the communities that fund and build schools, the welfare agencies, the bands of people who work together to support medical research or assist the poor and the afflicted, both here and overseas. They are the myriad of large and small associations that provide the organic vitality of our nation. And they have one thing in common. They are neither created nor controlled by the state. Instead, they arise from the desire to associate to fulfil common objectives. They are built on mutuality and trust. Starting with the family and extending to the many varied groups of people, they preceded the state. And it's the Coalition's strong, principled belief that the political community, that is the state, the government and its bureaucratic agencies, should be at the service of civil society. Where the state interacts with civil society, it should be to facilitate it. A good example was the introduction of associations in corporation legislation in the 1970s and 1980s. This legislation enabled associations to better fulfil their mission. It allowed them to attain the benefits of incorporation, to ease contractual arrangements, to obtain assurance and to protect individuals. It was light touch, enabling legislation, seeking not so much to regulate, but as to empower and to enable. It recognised that the sphere of government is separate from civil society. It acknowledged that the all-powerful state ultimately becomes Caesarian. It respected the principle of subsidiarity, that government should remain limited, and that the responsibility of the elected arm of government is to ensure that the bureaucratic wing should regulate only where and to the extent necessary. It was also built on the premise of trust, that individuals and organisations they established were motivated by the common good of their members. This is the common story of associating for the welfare of individuals concerned and their neighbours, whether in local communities or further away. Madam Acting Deputy Speaker, this understanding is now under assault. Under the pretext of simplifying and easing the regulatory burden on associations, the government proposes a new regulatory body, the ACNC. But what was promised and what has emerged from the bureaucracy are poles apart. A primary concern of the Labor Party's reform was that it should reduce administrative compliance and duplication by reporting agencies, enabling them to direct more of their limited resources to their charitable and related activities. This was reflected in the regulatory impact statement attached to the explanatory materials. Yet the bill, which was developed in a secretive process with a minimum of time for general comments, fails to meet this basic objective. The bill fails to provide any basis for the reporting requirements of companies limited by guarantee to be transferred to the new Commission, for relevant parts of the not-for-profit reporting requirements of Commonwealth agencies to be transferred to the ACNC, or for any clear commitment to obtaining the agreement for the rationalisation of government reporting requirements between the Commission and the relevant state and territory authorities. I'm informed, indeed, that there's been no meaningful discussions with the states and territories about these matters. Let me take one example, namely the case of non-government schools. In addition to the proposed ACNC reporting and accountability requirements, schools will continue to be subject to A, the Dewar Financial Questionnaire and the reporting requirements in accordance with the Australian and state government funding agreements and the Schools Assistance Act 2008, B, the ACARA My School data collections and reporting requirements that also include sector-neutral collection of financial data, and C, state and territory government minimum standards and reporting requirements for registered schools, including financial accountabilities, and in some states there are reviews taking place without coordination of the ACNC proposals. Indeed, there is very little indication that the Treasury bureaucrats behind the ACNC proposals have even consulted with, in any meaningful way, officials at the Department of Employment, Education and Workplace Relations, or in any comprehensive manner. This, Madam Acting Deputy Speaker, is just one realm of activity that would be captured by the ACNC legislation and which illustrates the flaws in the proposal. What had been promised as simplification turns out to be costly and burdensome additional reporting requirements with no reduction in red tape and no reduction in duplication. Indeed, the responsible minister now concedes that the premises upon which this legislation is being brought forward will not be met. In a recent speech, the Minister, Mr Bradbury, acknowledged the agenda is ambitious, stated that the government is now only, quote, working to reduce red tape, unquote, conceded that it will require, quote, more time for work to be completed, unquote, and agreed that the Commission is not going to, quote, solve all the problems overnight, unquote, of a fragmented, inconsistent and uncoordinated approach to regulation. In addition, the new system, far from saving associations the financial resources that could be best directed to their community activities, will cost them even more. The experience of the UK was that many associations have had to employ additional employees with regulatory, legal and financial expertise to meet the new requirements. The same will happen here. The Baptist Church, for example, in its submission to this process, has estimated that it alone will have to spend an additional $1 million per annum of scarce resources to meet the new requirements. Multiply this sum through the many associations upon which this regulatory system is to be foisted, and the cost to the community will be enormous. And the cost, I should stress, is to that sector of the community which is using scarce resources to deliver services mostly to people in need, and for a government to put in place a regulatory system which is diverting needed resources from services in the community into administration is something which is absolutely shameful. I was in the UK last week where agencies told me that they had to employ a whole new department of staff with legal, regulatory and accounting requirements and expertise just to meet the requirements of the Charities Commission in the UK. So let me turn then to some of the other deficiencies in the government's bill. Many of the regulatory requirements will be introduced by regulation. In other words, one of the most distrusted governments in Australia's history is asking the community to trust it when it cannot even meet the objectives it sets for itself. Secondly, in relation to the definition of charity, the basic religious charities proposal is very narrow and does not reflect the history or practice of religious bodies in Australia over more than a century. The very narrowing of the definition of religious activity is a dangerous precedent. The ACNC was conceived as a body to support charities and not-for-profits to enhance their contribution to society. Its role appears to be more about policing and enforcement, as outlined in the draft of the Australian Charities and Not-for-Profits Commission Bill, for example, the powers to investigate any breach of the law, powers to remove a responsible person, etc. No evidence has been put forward of cases of non-compliance by charitable entities which could justify the seemingly heavy-handed reforms or how the proposed reforms would address any current problems. Furthermore, the proposed Commission has a range of powers to interfere in and remove responsible office bearers, including ministers of parishes and congregations, in a manner which is totally unprecedented in this country. Which brings me to the central objection to the government's approach. The bill gives the Commission a power to re-register an organisation if it is conducting its affairs in a way that may cause harm to or jeopardise the public trust and confidence in the not-for-profit sector. The phrase public trust and confidence remains unclear. which creates much uncertainty and the possibility that the meaning of the expression will need to be decided through expensive litigation. This has been the experience in the UK, where, for example, the Charities Commission proposed that independent non-government schools would only qualify for charitable status if they offered bursaries to poor pupils. After expensive litigation, the courts reversed that position, restating the age-old view that the provision of education itself was a charitable activity. For those who contend themselves that the common sense finally prevailed in the UK, I invite them to consider the recent remarks by the UK Shadow Education Secretary Stephen Twigg that a future British Labor government could legislate to remove the charitable status of schools not serving the community, whatever that expression may come to mean. What this demonstrates, I contend, is that once the tentacles of government are allowed to interfere in novel and unprecedented ways with the activities of charities and associations, there is no limit to the possible interference. Worse, these and other provisions treat the civil sector with a state paternalism. If entities or their directors break the law, they can be prosecuted. If existing laws need strengthening, let the government make out the case for doing so, replete with examples of the breaches that need to be rectified. Some weeks ago, in a major policy speech I delivered on civil society, I invited the government to outline the mischief that this bill was intended to address. Neither before that speech nor in the weeks since has the mischief that this bill assumes been made out. It is in fact a power grab by government which will extend extraordinary powers to bureaucrats to reach into the affairs of organisations ranging from local congregations to international charities. Under the provisions of the bill, individuals ranging from a local parish minister through to the Archbishop of a diocese could be suspended and removed by the Commission. And every entity will be required to meet a new complex set of reporting requirements that will cost charitable organisations, including local congregations, thousands of dollars. Officers of the Commission will have powers to inspect and seize records. As the Associations Forum stated, in the work that Associations Forum does with associations and charities, we do not see that there is any major problem in governance systems. Let me just give an example, a flavour of the comments that have been made in various submissions to the inquiries and to in this process, which indicates that this is not just what I'm saying, it's what's being said broadly across the charitable and not-for-profit sector. Ad ministri, I quote, what we now have still appears to be a document that is designed to tightly control the charity sector with a plethora of regulatory obligations. We have a legal document full of red tape and inflexible regulation to show us what we must do or risk being penalised. The Anglican Archdiocese of Sydney, I quote, it is likely that we will need to employ someone on a full-time basis to deal with the compliance issues that this legislation is likely to raise for the Diocese of Sydney. I am sure we will not be alone in this regard. Indeed, too true. Australian Baptist Ministries, I quote, the reporting requirements for medium-sized entities are too onerous. In our view, the increase in compliance obligation will make it more difficult to fill volunteer roles within local congregations, as well as requiring more time to be spent on compliance matters and therefore less time on matters that will provide a benefit to the community. The Australian Catholic Bishops' Conference, again I quote, the lengthy list of powers proposed in the ACNC bill focuses on matters which appear more appropriate for a criminal investigation authority than for a body which is intended to promote and educate. The extent of information required to be disclosed to the register is unnecessary and burdensome in terms of costs and resources. The Australian Conservation Foundation. The ACF is concerned that rather than remove duplication, the ACNC bills will duplicate reporting requirements. Or the Australian Council for International Development, again I quote, the present drafting of the bill does not reassure ACFID or its members that it will actually reduce red tape because the drafting indicates that there is yet to be agreement with the states and it does not deliver a one-stop shop for the establishment of a charity or reporting by a charity. The Australian Council of Social Service, and this again illustrates the breadth of the objections and complaints about this bill, and I quote, the bill does not yet contain any provisions that make it explicit that the reduction of unnecessary compliance and regulatory burdens is a core object of the bill, nor does it identify these kinds of reforms as policy directions or drivers of the Commission's purpose or activities. There must be a direct link between the reduction of red tape and the objectives and functions of the ACNC. The Australian Institute of Company Directors, I quote, "We have had member feedback all saying basically the same thing as we have said." I will quote from one which I think is very pertinent. It comes from an aged care CEO, quote, "Every hour we pay for compliance, we lose about 1.5 hours of one-to-one support for our ageing residents." Another one from an Indigenous corporation states, "This legislation compounds the barriers that discourage pro bono directors offering their services to the not-for-profit sector." Well, let me turn to a person who is a favourite of the government at the moment, a life fellow of the Institute of Company Directors, David Gonski, who said this, "It concerns me massively that we might be the first country in the world to make being on a not-for-profit as a director more onerous than being on a for-profit." Now, that's Mr Gonski, revered in certain circles by this government when he gives this direct advice, which is consistent with everything that's been said by all of these other agencies, ranging from the major churches in this country through to the Conservation Foundation. It's obviously ignored. The Institute of Public Directors, I quote, "The bill lacks detail about the proposed interaction between the Commission, the Corporations Act and other legislation, and about governance and external conduct standards, which we consider make it impossible to provide meaningful comment on the bill as a whole. Key parts of the bill are confusing and overly complex and need to be redrafted. The bill in its current form will represent a major retrograde step by imposing substantial and unwarranted compliance costs on charities." Or Carers Australia, again I quote, "We are concerned with the apparent lack of agreement by the states and territories to give effect to the reduction in red tape. It is quite clear that due to a lack of constitutional coverage, the enforcement powers and governance standard regulations can only be used against federally regulated entities or where the organisation is subject to an external conduct standard. This will clearly lead to a two-tiered approach to enforcement, with some registered entities potentially subject to the enforcement and governance requirements, while others operating nearby with exactly the same situation will not." Or Catholic Health Australia, again I quote, "The effect of the bills would be to add additional regulation to the operation of most not-for-profit organisations." The CEO, Martin Laverty, said this, "The principal problem with the bill is that right now I cannot say to any of the chairs or the boards of directors of our organisations that from the time of the enacting of this bill, and indeed in the years ahead, as more of the powers of commissions come to be, this is a framework from within which you can govern your organisation. I ask those who are promoting the bill, and I'm genuinely seeking to understand, what is the problem that the Corporations Act and the case law that underpins it, that means that the not-for-profit organisations, we need a new set of laws that oversee their governance and indeed determine whether or not a not-for-profit organisation can be registered." He went on to say, "Our principal concern is that we have not yet seen what problem actually exists that requires the establishment of a new body of law, a new principle at law, to oversee public trust and confidence. It is our view that the Corporations Act currently provides like capacity for government to regulate these circumstances, few and far between as they are, that might arise to the potential for such a power to have been created." Or Catholic Social Services, again I quote, "The role of the Commissioner falls substantially short of the series of ministerial statements about the reform agenda from 2009 until early 2011. The draft does not require either the Commission or any other Commonwealth agency to take action to establish such a robust and streamlined regulatory framework or to be evaluated for making such progress. The specific problem identified in the explanatory memorandum is left unaddressed, the problem of red tape." Or the Chamber of Commerce and Industry of Western Australia. "CCI does not support any moves for the Commission to be a shopfront for the NFP sector." Chartered Secretaries Australia say their main concern with the exposure draft is the duplication of reporting that will result if the bills are passed in their current form. And I can go on and on and on of people, organisations, reputable organisations in this country serving the community who make these sorts of objections. Community Employers WA. A key objective is the reduction of red tape and duplication with regards to compliance, accountability and transparency. It is not to date and remains unclear that the bill will achieve this. The Conservation Council of South Australia, and I quote, "Whilst there is a national one-stop shop and a report once use often process, there remains a major problem in that at this stage state regulation will continue to apply." Or the Financial Services Council, who say the bill is not appropriately targeted to the currently unregulated NFP sector and instead extends the cost of compliance to other entities that are not supposed to be the focus of this reform. Eve Brown, the Senior Policy Manager of Trustees, said the bill therefore creates a new layer of regulation that applies to trustee companies and public trustees as trustees of registered entities. This is unnecessary and incompatible with current federal, state and territory regulatory regimes. Or the Housing Industry Association, who said that they consider that regulation of charities should be on a completely separate basis from the regulation of other not-for-profits. HIA also considers that not-for-profits which are companies should continue to be regulated by ASIC. Or the Independent School Council of Australia, I quote, "The regulatory burden will be increases on individual non-government schools, creating costly and confusing duplicative governments and reporting situations." Bill Daniels, the Executive Director, said this, "We spend a lot of our lives meeting with the Commonwealth and state governments through various national forums. I have been with this organisation for more than a decade. I've seen no reduction whatsoever in the reporting requirements. There's been no discussion whatsoever with the states or indeed with the Commonwealth Department that I am aware of that has involved the independent sector on any reduction in reporting requirements. The only discussion I've had with the Commonwealth, apart from the ACNC briefings we have received, is a less than perfect understanding of what is intended by the Commission. So there's been no discussion whatsoever of any reduction or any proposal to reduce anything." The Executive Director of the Association of Independent Schools of New South Wales, Jeff Newcomb, said, "I've been in this game for over 40 years. This will decimate school boards. There is enough concern out there now." Again, I can go on and on and on. The Institute of Chartered Accountants in Australia, quote, "The initial bill has two stated aims, one of which is to minimise regulatory duplication and simplify such entities' interactions with governments. The initial bill did not fulfil such an aim, and we notice that this aim is missing from the latest draft of the legislation." Kerry Hicks, the Head of Reporting, I quote, "The biggest issue with the legislation is the duplication it will create. Duplication and red tape reduction was the major theme of the reforms, so we do not feel the legislation has adequately addressed it." Mackinson and Dapache lawyers said this, "The ACNC bill will add to the burden of the vast majority of charities who will now have to provide an information statement and in many cases a financial report each year. In most cases there will be need for an auditor or other professional person to review or audit financial statements. This will not reduce red tape, rather it will add to it. The sector can have no confidence that this charity passport will be achieved based on the contents of the bill, the requirement for the sector-specific reporting in various areas and the failure at this stage to get cooperation from the states and territories to adopt the standard reporting and charity passport concept." Or Mission Australia. "The bill is not sufficiently well balanced by a commitment to enable the not-for-profit sector to reduce duplication of reporting and to require public confidence in the sector." Or the National Roundtable on non-profit organisations, I quote, "The bill does not distinguish between charitable funds and charitable institutions. Registration of a charity will not be voluntary. It is unlikely that existing charities that currently enjoy tax concessions will be in a position financially to forego these benefits. A charity which is structured as a company and is currently income tax exempt would be subject to income tax of 30% if it opted out." Or the Not-for-Profit Reform Council, again I quote, "The vast majority of directors in the NFP sector are acting in a voluntary capacity. We are concerned that this is not reflected in the bill. Any increase in liability for directors could result in individuals refraining from taking these roles." Or Research Australia. Of particular concern for not-for-profit entities was the risk that the creation of the ACNC and its registration and reporting requirements would simply impose an additional burden and a layer of regulation on the not-for-profit sector. RSM Bird Cameron Chartered Accountants. "We have particular concern about the possibility of duplication of reporting requirements for registered entities who currently operate as associations under state-based legislation." The St Vincent de Paul Society, I quote, "Any regulatory regime cannot adopt a one-size-fits-all approach. Furthermore, the development of any regulations ought to be done in consultation with the not-for-profit sector. The bill currently contains no requirement for the Commission to inform or hear an organisation before it makes a decision, an adverse decision against it. Surf Life Saving New South Wales. Reducing red tape by reducing duplication of reporting requirements and assisting the efficiencies of the sector. However, this will not occur without the involvement of the states and territories to align reporting requirements with the Commission's reporting framework. Or the Salvation Army of Australia. The bills suffer from a lack of reinforcement of this purported outcome and does not contain a specific object that addresses this reduction in red tape. Or the Uniting Church in Australia. I quote, "It's important to recognise that the introduction of any new reporting obligation on congregations, no matter how minor, will be another layer of legislative obligation and reporting for local members who are generally neither skilled nor trained for this burden." Uniting Care. Many of the implied red tape reduction benefits of a single national NFP regulator are predicated on state-territory government cooperation. The constitutional powers on which the Commonwealth relies for the establishment of the Commission highlights significant gaps in the Commonwealth's power to regulate not-for-profits. These gaps mean that the ACNC will or may lack the power to effectively regulate all registered entities. YWCA Australia. The most important goal of national regulation should be to remove the current duplication while streamlining requirements to provide consistency and minimise compliance costs. And if I had an hour to speak rather than half an hour, I could continue with the litany of criticism and complaint about this bill, about the process which has been engaged in by the government to bring it to this point of time, and about the extraordinary displeasure of the sector. The reality is that this bill is an extraordinary reach by government into the affairs of civil society. It assumes that people who give of their time and efforts, most often in a voluntary capacity, are untrustworthy and tainted. And furthermore, it is being introduced at a time when international practice is going in the other direction. New Zealand is closing its commission, and as reported in Civil Society, the head of NFP activities at the Australian Taxation Office has observed that efficiency initiatives in Scotland, Northern Ireland, Singapore and elsewhere also reflect this trend. Why is the Labor government proceeding with a flawed proposal that is being reversed in other jurisdictions? This is the same government which, when faced with egregious examples of corruption in another sector of society, namely the union movement, sits on its hands for years, allows investigations to proceed at snail's pace and doesn't lift a finger to deploy the kind of powers it proposes for associations against the questionable activities of some union officials. As we observed recently, union officials can blithely threaten to shift the expenditure of hundreds of thousands of dollars of their members' hard-earned money from the support of one political leader to another without as much as a raised eyebrow from this Labor government. Yet hard-working, decent, community-minded individuals who are going about their critical work for the good of our society are threatened with this Leviathan proposal. This is why we've announced, for example, that penalties under Fair Work Australia legislation will be changed by the coalition government to reflect the same provisions that apply to directors of corporations. As time is running out, let me simply summarise the coalition's approach. We reject this approach. We reject it not just because of the philosophical basis which I outlined at the outset. We reject it because overwhelmingly the sector rejects it as well. They see it as a heavy-handed, unwarranted interference in the activities of civil society in Australia. What we will do in government is that we would have a small body which would act as an educative and training body to help lift standards without these overbearing regulatory and enforcement powers that are being proposed by this bill. For those reasons, Acting Madam Deputy Speaker, we oppose this legislation, and can I give notice that if entrusted to government in the future, we'll not only continue to oppose it, we will repeal these provisions and we'll take it back to a sensible provision that respects the demarcation between the institutions of civil society which the government should serve, rather than the government seeking to have power over it in the way in which it does. There are two approaches to these matters, and which they can be summed up in two quotes. One approach is summed up in the opening words of the maiden speech of the former Prime Minister, Mr Rudd, when he said this: "Politics is about power. It's about the power of the state. It's about the power of the state as applied to individuals, the society in which they live and the economy in which they work. Well, this is a manifestation of that view, that the state should have power over individuals and organisations, which rightly it shouldn't. The other approach, the coalition's approach, is about empowering people, not exercising power over them. It's the approach that the Leader of the Opposition utilised recently when he referred to Abraham Lincoln's famous description of democracy as of the people, by the people and for the people. In conclusion, the political community should be of service to the associations of civil society. That is what the coalition will endeavour to achieve in government. That's why we oppose this legislation, and that's why, if we get the chance, we shall repeal it.
Before